of a job review, a job retention, a job interview, but also elements of a public function, like an election or, and so, the people who are being examined, you know, you've got to look at your heart. Okay, and, meanwhile, it's because I'm sure the judges and magistrates don't need me to tell them that, you know, you have people, the quality of people's lives here, and they want to have reason to trust and respect the process. I do note that the statistics we work from are somewhat questionable because we don't have very large samples. I look at a statistic and say, oh my God, 10% of those asked said this, and realize 10% is two people. So we do take the statistics with a grain of salt, but somebody said this. Somebody had thought they had reason to be upset with the judge or to say this is the best judge in the whole state. Someone had that opinion. So there are negative things, and we do need to look into them. It doesn't mean, I think it's unfortunate that often that involves that the proceedings are more negative than I feel comfortable with. We have to look at the negative comments. Let's introduce ourselves. I'm chair. I'm State Senator Dick McCormick. I represent Windsor County Senate.
Representative Chip Troiano. I represent Caledonia 2 District in the Northeast Kingdom.
And if any member of the committee wants to throw in some editorial comments, so I've already broken that. So.
I'm Senator Martine Rock-Ulick. I live in Burlington and represent Chittenden Central.
I'm Senator Ruth Hardy. I represent the Addison District. I don't take the comments from people with a grain of salt. I think it's really important to hear the comments from people, both good and bad, and helps us learn and do an important part of the evaluation along with everything else. So there's my editorial comment on that, Mr. Chair.
Hi there, I'm Angela Arsenault, representative from Williston.
I'm Oliver, representative of Sheldon and Swanton. My comment would be, I have been in the courtroom with all three of you several times and watched you, so.
State Senator Brian Collmore, representing the Rutland District.
Would you folks like to, everyone else participating, introduce yourselves?
Yeah, I'm Bob Palomini, Executive Director of the Vermont Bar Association.
Tom Zerray, Chief Superior Judge.
I'm Purcell, State Court Administrator.
Jessica Oskey, supporting Judge Warren, Judge Sherlock. I'm Lisa Warren.
Barry Peterson.
No trouble.
And this is our staff.
Eric Patrick, Prosecutor, Legislative Council.
Administrative Assistant Lindsay Schreier.
For clarity, when I use the term with a grain of salt, that means I don't take something as the revealed truth directly from the voice of God. That it requires some skepticism, which is to say virtually everything I hear. All right, let's, before we get started, does anyone have anything on the proceedings of the committee going forward that they want to suggest, or should we just get to work? Okay, we're a little bit ahead of schedule. We'll take up first the Honorable John R. Treadwell.
Swear.
Oh, yes, thanks. Would anyone who's going to be testifying? Do you solemnly swear or affirm that the testimony you're about to give in the matter before us shall be the truth, the whole truth?
Good afternoon, everyone. I'm John Treadwell. I'm a Superior Judge presently assigned to the Wyndham Criminal Division. I'm here to respectfully request retention as a Vermont Superior Judge. What I thought I would first do is introduce myself, give you a little bit about my background, and then discuss, then tell you where I have been presiding over the past 6 years, and then address the surveys and the survey results. I was appointed by Governor Scott in November 2017 to a vacancy created by his appointment of Justice Karen Harrow. This was a position located in the Wyndham and Windsor units primarily. Before my appointment, I had been with the Vermont Attorney General's office for many years, for about 17 years, primarily assigned to the criminal division of that office, where among my many roles was testifying in the legislature on criminal justice matters. I was probably the primary witness on criminal justice matters for the Attorney General's office for the 2000 through 2017 sessions. I recently had an opportunity to try and figure out how many times I've testified in this building. And I think my count was between 2009 and 2017, 120 separate dates or something like that. So I've been here a lot, and it's actually great to be back here. I didn't expect that when I was appointed that I would miss my involvement in the legislative process, but I do. And it is very good to be back in this building with an opportunity to go to a legislative committee. So I spent 17 years as a prosecutor in the Attorney General's office, the last 3.5 as chief of the criminal division. We're a statewide office. We handle prosecutions throughout the state, primarily focused on significant matters, whether homicides, public malfeasance, public corruption. We prosecuted law enforcement officers accused of criminal conduct. I also represented the state in post-conviction and other proceedings. And I was for 8 years cross-designated as a special assistant United States attorney and worked with the United States Attorney's Office on a number of matters. Before my time with the Attorney General's Office, I was a deputy state's attorney in Chittenden County for 3 years. And before that, I was with the Department of Corrections Legal Division for a year. So I've been a state employee since about 1995. So in 2017, I was honored to be appointed as a judge by Governor Scott. I was sworn in November, took the bench in January in the Wyndham Civil Division. Despite my long career as a prosecutor, they sent me to a court where I was working for 2 days a week on civil matters and 2 days on the domestic docket. The Wyndham Civil position is basically a split between the domestic and civil docket. I did that for 8 months. It was a challenging experience because not only was I learning to become a judge, a very different role than being a lawyer, but I was also dealing with legal issues which I did not have a significant professional background in. In September of 2018, I rotated into the Wyndham Criminal Division, where I was assigned for the next 3 years, the last year of which I was the presiding judge in Wyndham County. There, my role was 4.5 days a week. I was assigned to the criminal docket, half a day a week. The RFA docket is handled by the criminal judge in Wyndham County, usually. There were challenges during that 3-year assignment, the primary ones being the implementation of the Odyssey case management system, and at exactly the same time, COVID. We started with Odyssey on March 2nd, 2020. We shut down for COVID on March 16th, 2020. I actually think that that was probably helpful in terms of implementation of Odyssey because it significantly reduced the caseloads in the courts that we were dealing with because we didn't have in-person proceedings. We were just, so we were learning how to use the new system while trying to manage those cases that we could still get before the court. My role as we started to come out of Odyssey was basically reinitiating criminal trials mostly. I was appointed to the Jury Restart Commission, Jury Restart Committee that this Vermont Supreme Court created, and Wyndham County was one of the courts that was identified as one of the first places where jury trials were supposed to restart. So that involved work with all the stakeholders, the lawyers, the prosecution and the criminal defense bar, court staff. We had public health expert working with us to try and reconfigure the courtroom so that we could conduct proceedings in a manner that was consistent with public health and public safety. So we moved the witness box from next to the judge to right in front of the judge. So the witness was testifying in a place where they were 10 feet away from everyone else. We spread the jurors around the room so there was spacing between everyone. We used that process, I think, for 3 or 4 months after the restart. The first case we picked was actually dismissed by the state before we went to trial. But we did use that process, and it was an effective way of conducting jury trials consistent with what we were being asked to do in terms of distancing, social distancing. We were requiring everyone in the courtroom to be masked. We had clear masks for the witnesses because the defendant's constitutional confrontation rights meant that they needed to be able to see the witness during the witness's testimony. Ultimately, I rotated out of the Wyndham Criminal Division in September 2021 and went to Windsor Criminal Division for the next 2 years. When I got to Windsor County, that was what is called a limited access courthouse. So we couldn't do any significant in-person proceedings in the courthouse. We did arraignments, but pretty much everything else was conducted remotely. There was a significant trial backlog. We made an arrangement with Wyndham County that we would try our cases in Wyndham County. So there were 2 trial weeks a month in Wyndham County from September 21 through March of 22. One was for Wyndham, one was for Windsor. And I would go down there and try the Windsor cases. The Windsor County Bar was not happy. I think one of the writing samples I've provided to you is a challenge to my order transferring a case to Windsor County for purposes of trial. Realistically, there were no other options. We needed a location where we could do in-custody trials. The Wyndham County Courthouse was certainly capable of doing it. It also had the advantage of I was very familiar with it. I was familiar with the staff there. We could operate trials there fairly simply. Ultimately, in March or April 2022, improvements were made to the air handling system at the courthouse at White River Junction, and we were able to do trials in White River, basically reverting to pre-COVID procedures. I focused heavily on efforts to eliminate a backlog in that county. I think I was successful, but that is not, but that is entirely due to the joint efforts, both of all of the staff and the bar in that county. We had approximately 1,700 active pending cases when I rotated in September 21. When I rotated out in August 23, we were down to 950 active pending cases. The attorneys, I think, appreciated the fact that the significantly lower caseloads allowed them to more time with their cases. We were moving cases more quickly through the system. But I want to again stress that that was only possible because of the work of the bar, and particularly the extremely experienced and capable court staff in Windsor County. The regional clerk, Ann Damone, and the court operations manager, Dawn Hudson, both deserve enormous credit for their willingness to try new things that I suggested for them. What we came up with together. Starting in September 2023, I went back to Wyndham County, again in the criminal division. I'm in my 6th straight year in the criminal division. And I'm working on a backlog in Wyndham County. I think the backlogs in each county are somewhat unique. There are different reasons why the backlogs can occur in different places, but we are working on trying cases. We are adding extra trial weeks. We are doing some things with the docket to try and make court hearings more efficient. There have been some struggles with hearings through the fall, just given the enormous number of cases that are being scheduled in a single day. Each month we have a pretrial conference day. That is the last hearing before jury draw. That's basically the hearing when we decide what cases are going on the draw list. The attorneys are reporting whether their cases are trial ready, whether they have conflicts with any of the trial dates. September pretrial day had more than 190 cases on. There were more in October. The October day had 230 cases on. It was 140 criminal defendants. We got the day done within the time allotted, but the reality is that's too many people in the courthouse. That's too many cases on the docket. That's too many cases for each attorney to meaningfully engage with their cases. And it's too much for us to get through the court in a day. So I have capped the number of cases that we are doing on pretrials going forward at 40 defendants in the morning and 25 in the afternoon. And I'm hoping that that will provide a meaningful opportunities for the attorneys to have discussions with each other, defense attorneys to have discussions with their clients, so we can resolve more cases in a way that's more effective. I also had concerns with just the number of people that were in the building and the challenges that posed for security in terms of getting people into and out of the building. So those are the challenges that I've been dealing with recently. I wanted to express my appreciation for this process. One of the things that I struggled with when I was first appointed is lack of feedback. The role is very different between a trial lawyer or litigator and being a judge. And there are not many opportunities for me to hear how I am doing, what I'm doing right and what I'm doing perhaps not as well as I should be. I was fortunate when I was appointed that during my first 3 weeks on the bench, on the days that I was covering the civil docket, I had then Judge, now Justice Cohen sitting with me. And when I was covering the family docket, I had Judge Wesley, retired Judge Wesley sitting with me. So I had an opportunity for very experienced judges to help me right at the start. Since then, feedback it's a little hard to find at times. No disrespect in saying that. The reality is, if you're lucky enough to have an experienced judge come in and watch you for a hearing, that's great, and that can be really useful. But there's no good way to hear from the lawyers if you're doing okay. There's no other good, meaningful way of knowing whether you're doing things right or doing things wrong. You can get a sort of sense of whether people are happy in the courthouse or not. But what I have really appreciated, what this process has done is given me an opportunity to see what the people who are willing to respond to surveys say about the job that I have been doing over the past 6 years of the period that the surveys were collected. And I will say that I have learned from what I have read. Procedural fairness, procedural justice is a core component and must be a core component of what we do. The people who are before us in court, not just the defendants and the lawyers, but everyone who is in there, the witnesses, the jurors, victims, the public at large must have a sense that the system is being fair, that the people who are in front of the court are seen and heard and are being dealt with in a fair manner. It is clear to me in reviewing my surveys that there have been times where I have not succeeded in that process, that people have perceived that they are not being seen or heard. And I, having reviewed the surveys, are recommitting to making sure that I am clear about what I am doing and why I am doing it. One of the unfortunate consequences of the fairly significant caseloads is when you've got to move a lot of cases very quickly, you sometimes don't have the time to put as much explanation into what you are doing as you would like to, and you may not have the opportunity to hear freely from the parties. You may have to tell them that the time is over. But I think what I have gleaned from survey responses is that there are people who have been dissatisfied with their experiences, and I need to pay attention to that going forward. Timeliness of decisions is another issue that I think that I can struggle with at times. The court doesn't stop. The time for writing is somewhat limited. There are pressures. And clearly, if people are waiting for a decision, that is not helpful for them in terms of moving on with their lives. I also recognize what my background was before I was a judge, and that in the criminal docket, people are aware of that. I think I have been very effective at holding the state accountable. I consistently decline to find probable cause for charges if I found that the state has not provided a sufficient factual basis to support the charge that they have filed. I have declined to issue numerous search warrants or modified those search warrants. I have dismissed cases, more than one, where I have found that defendants has been prejudiced by discovery violations by the state. I am more than willing to hold the state accountable for its actions and ensure that the state, which has enormous authority and power in the criminal justice system, is required to comply with their obligations. There are times, it appears also, where I have perhaps been more curt with litigants and litigators than they wish. I would never knowingly be rude to anyone in front of me, but there are times we need to move things forward, and I have expectations regarding civility in the courtroom. And if I perceive incivility, I will respond to it, and I will respond to it to ensure that it does not continue. And sometimes that needs to be done sharply. I think those were the main issues. I have thought extensively about the surveys. I will continue to think about them as I go forward. And I want to thank you again for the opportunity to be here, and again, respectfully request that I be retained as a Superior Court judge. If there are questions, I am happy to try to answer them.
I just comment, legislators do not have the problem of not knowing how we're doing.
Yes.
Look at your email tonight.
We hear from our and others constantly. You've sort of gotten ahead of me. You've answered the questions I was going to raise. So hand it off to the committee. Yes.
Thank you, Mr. Chair. And welcome, Judge. So there are proposed bills in both chambers. Senator Hardy and I, as a matter of fact, have proposed one bill that attempt to address various reforms and conditions of release that potentially could aid the judiciary by giving judges a little bit more discretion when imposing those conditions. I wonder if you could talk a little bit about whether you feel, and forgive me if I'm not going to use the right word, constrained a bit presently with what's in statute, and what specific provisions of anything that's coming in terms of legislation that might allow you necessary discretion.
So I wouldn't want to step on the Chief Superior Judge's toes in speaking for the judiciary before your committees. There are, as I'm aware that there are a number of bills before the committee that present policy choices with respect to conditions of release. I don't feel constrained by the existing statutes in terms of the conditions that I can impose. I have discretion. I understand what my legal obligations are, my constitutional and statutory obligations in terms of imposing the least restrictive conditions possible. I also understand that cash bail can only be imposed to mitigate the risk of flight. I certainly see the frustration that is expressed in the media and the public regarding what is perceived to be repeat offenders cycling in and out of the system. If people are residents of the community and are not fleeing, bail is never going to be appropriate under our statutes and constitution. If we are seeing repeat offenders, I think the most effective way for us as in the court system to address that is to move cases to resolution, to trial as soon as we can. The reality is I would really like to be able to set cases for trial more quickly. I have tried 6 multi-day felonies since I rotated back into Wyndham County. 2 2017 dockets, 2 2018 dockets, a 2019 docket, and a 2020 docket. So nothing more recent than 3 years ago. The backlog in the system is preventing us, from my perspective, moving us cases forward as quickly as I would like to. Does that answer your question, Senator?
Yes, indeed. I just have a quick follow-up, I hope. We're a member of the Jury Restart Committee. So you're very aware of what we pay jurors. I think it's $30 a day. And that has not changed since, I think, 1977. It's been over 40 years since we've sort of given them a raise. But would you want to offer a suggestion as to what a proper day's service could be? I know there are people making substantially more money than that an hour, and I assume most trials go longer than an hour.
So after the jury has returned a verdict, I often meet with them briefly. I don't discuss the case. I talk to them about procedural issues, what their experience was like in the courthouse, what we can do to make the experience as a juror more less burdensome for them, because I realize that we are compelling people to participate in a civic duty. I regularly hear about $30 a day. I had a jury recently that arrived at 8 o'clock in the morning. They were for day 3 of a trial. They've returned a verdict at 8:30 at night. So that's a 12+ hour day for $30. I think the Restart Committee report noted that the juror fee had been set in the 70s and suggested that the legislature raise that fee. I have had jurors tell me that they cannot serve because of the financial constraints, and $30 just won't do it. I would think that we would increase potentially the pool of jurors who would be willing and able to serve if they were paid a daily living wage.
Good answer. Thank you, Judge.
Thank you, Senator.
Question.
I'll second that. Yes, Representative Arsenault.
Thank you very much, and thank you for being here. So I'll just focus a little bit on some of the feedback from the surveys, specifically some attorney feedback.
Mhm.
And I'll note before I start that I was really, I want to use the word impressed. So come up, use a different word in your mind if you can do that for me. With the nearly unanimous, favorable, excellent, very good and excellent responses among court staff, assistant judges, and non-attorneys. I noted that and appreciate that.
So did I.
It's important.
Yeah.
it tells me a little bit about how you are with the people you work with and what kind of workplace environment you might be setting and establishing what kind of culture, and that's really important. I serve on House Judiciary, and though I've only been in office for a short time, we hear over and over on our committee about the lack of focus, care, attention to victims in our criminal process. So a couple of comments stood out to me and the attorney feedback about treatment of victims. One respondent saying an inability to acknowledge, understand, assuage, or relate to victims in any way, and then another little to no sensitivity to the harm a victim has suffered. And I just wondered if you could talk a little bit about how should a judge relate to victims of crime in the courtroom, and what kind of expectations do you have for yourself in that respect?
Okay. Those were comments that I had noted as well, and were at least in part what I've been thinking about regarding procedural fairness. Victims are in the courtroom having done nothing except be a victim of crime. They in the criminal justice process, I spent a lot of years as a prosecutor working with victims. I understand and appreciate that the process seems at times unkind and unforgiving because it is not focused on them, because it is the state proceeding against a defendant. Victims have statutory rights in terms of right to presence or right to comment. And I do consistently, as part of the process, inquire of the state whether the victim is present, whether the victim has an impact statement to provide. There are certainly times when, as a judge, while I can acknowledge the victim's presence and views regarding what we are doing, if there is a request to reject a plea agreement or for something different, that may not be an option that is available. But I am certainly aware that I have left victims in at least a couple of cases dissatisfied with my work as a judge and the criminal justice system as a whole. That is not acceptable to me.
Yes, one follow-up, just thank you for that. I'm curious, I know that there's I know a little bit from Judge Zone about some of the judicial training that is offered and available and have been required and in some instances. And I'm wondering what sort of trauma-informed training there has been for judges, or if there are any that you've engaged with.
Get the friend.
Yes. I can't specifically recall any at this time. I didn't know that through my career as a prosecutor, for being a judge, that was certainly some training that I was aware of and was involved with. I'm also very aware that the defendants I see often have a trauma history. I also am very aware that the defendant I see before me today may be a witness tomorrow and a victim in a case the following week. It is an unfortunate reality of the system that many people we interact with have significant trauma history.
Oh, we skipped. Do you want?
Yeah,
Yeah.
I'd be happy to take one. I'll take advantage of this opportunity to ask you your opinions, having served in many courthouses the current state of security in the buildings and your thoughts on them and what you would do to improve them. I know there are different variations. Every courthouse has different physical structure and as well as humans participating in the protection of it. Some of it's private, some of it's judiciary, some of it's sheriff. And how do you feel safety wise within the building?
Thank you, Representative. So I've primarily been in two courthouses, White River State Courthouse and the Brattleboro Courthouse. Although I've spent a little time in Woodstock and a little time in New Fane as well, and also Chelsea. In Brattleboro, security is provided by Securitas. But there is a deputy sheriff present. Now, when I was last in Brattleboro, there was not a deputy sheriff in the courthouse, which caused a problem because when people turned themselves in on arrest warrants, we couldn't take them into custody. We had to send them up to the Brattleboro Police Department, which is on Black Mountain Road, some distance away. It was not convenient or effective. In White River, security is provided with judiciary court officers, but also sheriffs at the door. I have had an excellent experience in both places. I could not speak more highly of the transport teams, the state deputies that I have worked with in Windsor and Windham County. They both teams of two officers have been excellent to work with, have been very effective at working with perhaps more difficult people. I had a trial over the summer with an individual who expressed, denied he was a sovereign citizen, but expressed sovereign citizen type beliefs, refused to accept that he was the person, did not want to be called by his name, was in custody, had been held for almost 2 years pre-trial. I tried the case because the criminal judge in Brattleboro at the time had a conflict with the case. The Windham transport deputies were incredibly good at working with an individual who could be quite difficult in the courtroom. I and my law clerk had listened to all the prior proceedings in front of other judges, and the outburst in the courtroom of comment, we were able to manage that. So my experience with both security and transport deputies has been excellent.
Thank you.
Are you done?
I'm good.
Thanks. Senator Hart.
Okay, thank you. Just didn't want to.
No, thank you.
Thanks, Judge, for being here, and I enjoyed reading your file. I note that you have connections to both Ithaca and Madison, Wisconsin, as do I, so that's really nice. Senator Collmore and I are sort of on the same page with our questioning. I was going to ask you about the jury pay, and I hope that there's part of your budget request is some increase for jury pay, because $30 a day is ridiculous. So I'm glad you noted it because I didn't know it was that low. I appreciated the question that Rep. Arsenault asked you about trauma-informed training. And it's concerning that you don't remember getting any. I bet you when you leave here tonight, you're gonna be like, oh yeah, there was that thing. Even if you do that, I really encourage you to get better and more memorable trauma-informed training, because your point about victims, defendants, and witnesses all probably having trauma, or definitely, is important. And I think that would help you address some of the comments that you saw that you might have noted are concerning, I would assume. But I wanted to ask you about the 3 cases. I was interested in the 3 cases that you submitted. First of all, there was one on conditions of release and bail. So that's why I was thinking about asking you about that. And it seems to me like you, at least based on these two cases, were able to effectively use the conditions of release and bail statutes to make a decision to both deny bail and to affirm conditions of release, namely that the guy couldn't go back and live in his neighborhood because of the problems with being so close to the victim. Would you agree that you felt, at least in those cases, able to work within the statutes, or would you have been able to reach a different conclusion had it been?
The facts in combination of the law got me to the result that I got to. In both cases, in the hold without bail case, the state's evidence was overwhelming.
Yeah.
And the defendant's history led me to conclude that it would not be a good exercise of discretion not to detain the defendant. And I think I was clear in what I was doing in that case. I will say that the opinion is written at least in part to provide guidance to a state's attorney's office as to the law. In that case, with respect to the conditions of release
Situation.
case, it was a slightly unusual case because they were asking me to rely on evidence from a hearing that I didn't preside over. So I had to go back and review another hearing. But it was a case, again, where the facts led me to a particular conclusion that conditions were required under 3 separate subsections. The same condition was justified in not lifting a condition restricting where the defendant could.
Yeah, I especially appreciated the photo of like how close the houses were together. But the third case that you submitted was where you mentioned the moving a trial from Windsor to Wyndham.
Yes.
And there was a pushback on that. And you found that the transfer to another location wasn't warranted at that time. And I will admit, I read this a few days ago. When I read that, I was surprised. So I didn't feel like where you were going with your argument led to that. So wondering if you could help me understand your reasoning in that case.
Sure. The decision was one of a number of decisions addressing this issue about challenges to change of venue. And I wanted to be very clear as to how I viewed the standard and the law, and if the attorneys were going to convince me not to transfer a case, this is what they had to work around. This case was relatively unusual. The vast majority of cases involve public defenders. And in this case, it was private counsel who made the point that his client would have to pay for him to drive to Brattleboro for trial, but also
Pay the attorney to drive to Brattleboro?
yes, for travel time. Yeah, in addition to the
Lawyers, I'm sorry.
in addition to the cost of trial. But the other reality here is that I had many older cases on the docket. So this one hadn't risen to the top yet of likelihood for trial. But the idea was basically to frame for the lawyers what I viewed the standard as for transfer of venue for reasons of we couldn't use the courthouse.
Okay, so you were using this case to make your point for other cases as well. So maybe that's why I was a little surprised with the outcome, because I was like, it seems to me that you're making the case that you can move a trial, and I specifically circled neither the federal nor the Vermont Constitution preclude the Vermont legislature from providing for jury trials to occur in counties other than the county where the offense was alleged to have been committed. And so that seemed to me like you were leading to the conclusion of, oh, I can transfer this case. And then you didn't.
So when drafting an opinion, I am not, the audience is not just the parties in this particular case. there are multiple audiences for any opinion that obviously the parties are the primary audience, but there's also potentially the Vermont Supreme Court if there's an appeal, and I want this to be coherent and understandable for them. But there's also a public component to who the audience is for any opinion. And the way I write is intended to provide a standalone document that any person could pick up and understand what the case was about, what happened, and what the sort of broader legal conclusion is that I have drawn that they could then apply going forward, and other attorneys could see and understand that in cases they had in front of me, there would be clear expectations as to where I might be going.
Okay, that's really helpful. I'm sure that's appreciated by the attorneys who come for you in the courtroom, that you're clear about what you're doing and state it in your cases and why you're doing it. And yeah, anyway, okay, thank you. I enjoyed reading your cases and your file, and I'm glad to hear that you are contemplating the comments heavily or thoughtfully.
Thank you, Senator.
Yeah.
Thank you. Thank you very much for everything you've said. And I agree with Senator Hardy that it's nice to see that you listen to the constructive criticism and have taken it and will hopefully act on it. That's wonderful to hear. You had one quote that you mentioned a few times. I found it interesting. If we are to keep democracy, there must be a commandment, thou shalt not ration justice, which seems to suggest that a sound system of justice is extremely important to you. And you've mentioned a few things tonight, pay for jurors, capping the amount of hearings that you hear over the course or see in the course of a day. Is there anything else that you might want to bring to our attention that could improve our justice system here in Vermont?
Well, I thank you, Senator. Clearly, the backlogs that we are struggling in with are critical. The delays in processing cases have consequences not only for the parties to the proceeding, but for victims and everyone else who's sort of in the circles surrounding cases. It also makes the cases much harder to address when they ultimately do get to trial. When I was speaking to jurors after one of the trials from a 2017 case, they asked why the case had taken 6 years to get to a resolution. I think the reality is we need to address, we as the judiciary need to address the backlog and continue to move cases forward as quickly as we can, consistent with everyone's rights, to get matters resolved.
Or work to settle out of court? Or work to settle out of court?
Yes. In my experience in the criminal court, the most effective tool for getting parties to settle is the possibility of trial. It's only when you're getting to the point where the decision is going to be made that there is real pressure to resolve the case.
Anyone?
No, thank you.
Judge, thank you for being here. So I think that Senator McCormick and I have been on this committee the longest. And so when I review these comments and grades, I have maybe a different perspective than some of the others. And it's sort of like a diving competition. You take the best grade and the worst grade out, and you just got to build from there. But it always seems to be someone that dogs the judges with poor comments. So and when it's 2% of the respondents, you don't take too much stock in it. I did, however, look closely through the comments that were made, which were considerably, a considerable number compared to some other years that, you get one or two maybe. You won that by 12-8, positive to negative. So that also has an impact. I mean, what I find interesting then, and I think in all of the files that I reviewed on this, you see bias toward prosecution on one line, and the very next line is bias toward the defendant. So again, you're kind of like, where is this? So I think what you said here tonight is very positive. I think that you really need to take the feedback from these files and take it back to your court with you and keep it at the top of your mind. You need to keep it in mind all the time when you're sitting on the bench, because you're sitting above everyone else in the courtroom, and you need to have those considerations that have been brought to your attention. But I did want to talk a little bit about one comment that I read, and it came just prior to us taking some testimony in my committee of corrections and institutions, and I was assigned to address the challenges to continuing pretrial detention for defendants brought by the Defender General. After hearing over several days, I issued my decision concluding that the rights of a particular criminal defendant were not in violation by continued pretrial detention. That kind of jumped out at me because about a day or two later, we took testimony from two individuals who had been in corrections. Now, granted, not a whole lot of information on what transpired in this hearing, not a whole lot of information on the folks that we heard from, but they were held pretrial detention, one for 18 months and one for 3 years. And they were receiving the reason why they were in our committee, they were receiving horrible medical care while they were incarcerated. And that was very disturbing. And it came on the heels of reading this. So I just wanted to bring that to your attention. I have to disagree with you on that. I think that it should be closely examined as to the conditions that will hold a criminal defendant incarcerated for 18 months or 3 years pre-trial detention. It really seems over the top to me.
I agree that pretrial detention is an enormous intrusion on the liberty of presumptively innocent persons, and should only be imposed when absolutely necessary. I think the case that you're referring to that I was involved with, which was the challenge to pretrial detention at the outbreak of the COVID pandemic, and there was a hearing over multiple days with multiple witnesses, including witnesses from the Department of Corrections. We heard from multiple inmates as well as to their experience with corrections response. And there were medical experts who testified as well. Ultimately, I concluded that the defendant in that particular case's constitutional substantive due process rights were not being violated by pretrial detention during COVID. Ultimately, an appeal was taken, was dismissed before the Supreme Court decided the case. I have on a number of occasions addressed challenges to continue pretrial detention on the grounds that detention is extended too long. There is a defendant who I believe challenged his detention pretrial on 4 separate occasions. 3 of those appeals were from decisions I made. Ultimately, I concluded that his detention pre-trial had violated his constitutional speedy trial rights. The state took an appeal, and the Vermont Supreme Court disagreed or concluded that I was incorrect in my analysis, and the matter was remanded to me for sentencing.
Well, that's good to hear, Judge. I appreciate that for a great deal. As I said, it's of concern to me that that kind of thing happens. But thank you. I appreciate your candor and that you had considered that issue in a different direction. And just as you should, every case is an individual case brought before you as a judge to determine and mete out sentencing and decide issues surrounding the law. And I certainly appreciate that and I respect that. And thank you very much.
Thank you, Representative.
One last thing, I waived questioning because you had already answered my questions. In the subsequent questioning, the issue came up of sensitivity to the victims. And you did acknowledge the importance of it. You acknowledged that you had read that and you were aware of it. What exactly do you plan on doing to remediate that situation?
I thought about that in detail, and I have committed to myself to remaining present in the case that is in front of me as a first step. The pressure in the docket makes it very easy not just to focus on the case that's in front of you, but the number of cases that are coming, and to perhaps skip some steps in the matter that's in front of me in order to move on to the next case. One of my conclusions based on review of the surveys is that I had not adequately explained what I was doing and why I was doing it. That I need to do that more clearly with the people who are in front.
Every judge has a hard job there. Good luck with that.
All right. Thank you, sir.
Committee, any more?
Just this is your first retention, yes or no?
Technically, no.
Okay.
I was here, I started on the bench in January of 2018. I went through retention in March of 2018.
Sorry.
So
Okay.
it's effectively the first full retention that I've got.
You got a pass, I hope, the first time.
The only other person in the retention group with me had fewer votes against him than I did, even though I'd only been on the bench.
Thank you, Jan.
Thank you very much, everyone.
Thank you, Judge.
And we'll take up the Honorable Lisa A. Warren. Oh, should we take a couple of
I
minutes?
just need to get some water. Need to get a.
Okay.
While you're at it.
I'll have one.
Pass the cookies. Do we have the right sign? I just sat down. I didn't.
I don't have it.
No, I think you do. Right sign is.
Oh, okay.
Yeah.
It's closed.
Yeah.
Look at the pictures. I actually